5 seconds to go. Start. In all these cases at hand, the High Court does not appear to have focused on the requirement to have due regard to the qualifications required by the agreement or other considerations necessary to secure the appointment of an independent and impartial arbitrator. It needs to reiteration that appointment of the arbitrator or arbitrators named in the arbitration agreement is not a must, but while making appointment, the twin requirements of subsection 8 of section 11 have to be kept in view, considered, and taken into account. If it is not done, the appointment becomes vulnerable. In the circumstances, we set aside the appointment made in each case, remit the matters to the High Court to make fresh appointments, keeping in view the parameters indicated above. In the aforesaid decision of the case of Northern Railway Administration held that the High Court in the said case did not appear to have focused on the requirement to have due regard to the qualification required by the agreement or other conditions necessary to secure the appointment of an independent and impartial arbitrator. In the aforesaid decision, this court also concluded that since the requirement of subsection 8 of section 11 was not at all dealt with by the High Court in its order, the appointment of an arbitrator without dealing with subsection 8 of section 11 of the Act became vulnerable, and accordingly such appointment must be set aside. Similar is the position in this case. In this case also, before appointing an arbitrator under section 11(6) of the Act, the High Court had failed to take into consideration the effect of section 11(8) of the Act as was done in Northern Railway Administration. In view of the discussion made herein above, and particularly in view of the principles laid down by this court in Northern Railway Administration, we set aside the impugned order and remand the case back to the High Court for fresh decision of the application under section 11(6) of the Act, and while considering the application afresh, the High Court is directed to take into consideration the aforesaid decision of this court. It is clear from the perusal of the judgment of the High Court and the records before us that the High Court had not terminated the mandate on the ground that the arbitrator could not pass the award within time. The principles laid down in the said decision cannot have any application in the present case, although the decision rendered in this case in the decision under the Arbitration and Conciliation Act 1996, taking into consideration the arguments of the appellant, it is necessary to mention here that the court does not have any power to extend the time under the Act, unlike section 28 of the 1940 Act, which had such a provision. The court has therefore been denuded of the power to enlarge time for making and publishing an award. It is true that apparently there is no provision under the Act for the court to fix a time limit for the conclusion of an arbitration proceeding, but the court can opt to do so in the exercise of its inherent power on the application of either party. Where, however, the arbitration agreement provide the procedure for enlargement of time and the parties have taken recourse to it and consented to the enlargement of time by the arbitrator, the court cannot exercise its inherent power in extending the time fixed by the parties in the absence of the consent of either of them. The counsel for the appellant further contended that the High Court could not have terminated the mandate of the arbitrator, with reference to the contention made by the appellant that the arbitrator, having concluded the proceedings, could not be said to have failed to act so as to attract the provision of section 14 of the act, which will call for termination of the arbitration proceedings. It is pertinent to mention here that the arbitrator had not concluded the proceedings as had been agreed to by the parties within the time fixed for doing so. It is an established statement that the said mandate of the arbitrator was terminated only because of the fact that the arbitrator, having failed to conclude its proceedings within time, did not warrant to be continued as an arbitrator in the absence of the consent of both the parties. It is clear that the arbitrator had extended the time provided to it without any concrete reasons whatsoever, and thus his mandate was liable to be terminated. Subsection 1b further states that the mandate of an arbitrator shall also stand to be terminated if he withdraws or the parties agree to the termination. Stop.